hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And I don't see any life over in the courtroom yet, but I thought it should be happening soon. So let's take it in here.
Now, you didn't say the cat jumped on his wiener, did you?
Say a word. Oh, and go ahead and put yourself on mute now.
Okay, that's it. Are we started now? I get to work some of my favorite clips. All right, let me see. What do we got here? We've got a dead courtroom here. This is not looking good so far. All right, I imagine they'll be in. What are we looking forward to today? Tell me in the chat. I'm hoping to see the opening statement. Well, hell yes, I'm fresh out of the shower. I'm fresh out of the shower, and I just got. Well, I know one wiener is going to be here. Oh yeah, John, I will get you a link right now. Let me do that. Let me do that. Look at this quality Law Talk with Mike programming here. Don't worry. We'll be sitting here for hours. I'll get John in. That'll help. Let me see here. How do we do that? There we have it. John, all good. Link sent. So come on by. We got a pile of nothing happening. Oh, there he is. Oh, you're gonna do this to me this morning, huh, StreamYard?
Hello.
Good morning.
Good morning.
How you doing?
I'm doing all right. I was up until 2 trying to take care of actual stuff because this took up our entire day, but I'm doing okay.
All right, everybody, can you hear John? He's always quiet to me in my thing, but then when I see the replay, it's not bad.
That's a great question. So this is a mic check.
Let me see here.
All right, Gracie gave us the one.
Wait, somebody was kind enough to already super chat me this morning, and now I'm looking for it.
I could find that for you, maybe. It was pretty early on.
There we go. Pincalo the Driving Ape. This trial is just absolutely batcrap insane. Indeed it is. That being said, will today be Darrell Brooks? A word of the day. Yesterday was leading. I don't know what he's on to. Oh, yesterday he had so many good ones. Analyzation was one of my favorites, but there were more. Dr. Seuss words.
Ground.
I'm sure we'll get more today. He did drop a token, as I do believe. He displayed all of his glorious conjugation yesterday.
Oh God.
Although yesterday, thanks for hanging with me. You and Ben, you guys just stayed in the foxhole with me.
Oh, honestly, I couldn't look away. I was hoping the state would rest, and I think they have one more witness this morning, so we might get him. And the last witness is probably not going to be anything major, so I'm waiting for that opening.
Well, yesterday we were going along fine. We were having fun making fun of you for being a ginger, and then they come rolling in with that horrible testimony from the car and the picture, and everybody just simultaneously and appropriately just went into rage mode.
Yeah, I'm wondering, what do you think the over-under is on how long he tries to hold up the court this morning on more nonsense?
I mean, he'll push as far as he can. He'll kick it off. He'll kick things off by questioning jurisdiction.
Oh, well, that's talking about the opening. I'm just thinking he's going to waste their freaking time for another hour again before they even get to bring the jury in.
Yeah, I think. I mean, I don't think he thinks much, but generally, I think he realizes this is his last time out of prison.
Yeah.
And he just wants to elongate it, and I don't think it's much deeper than that.
I think you're probably about right.
So, yes, if he can waste an hour on preliminary matters when 30 seconds would suffice, he'll do it.
Yeah. No, you're probably right. I mean, I'm wondering, God, his opening, I'm so looking forward to it because I have no idea. Like, I know sort of where he's going to go. I wonder what the state's motion is.
Look at this, Amber.
Amber, do you know what the state's motion is?
I love it when they explain things to me. Okay, so then the day I was like racing around, hopping in the shower. My hair was still wet, and I actually get on here on time, and then they move it back. But that's okay. State's presenting a motion first. Okay, that could be anything.
David Edwards, he has no defense.
What's interesting, though, and we've discussed this a few times, is he doesn't have a viable defense, but he's got 5 or 6 things to go with. One is it's not me. You can't put me in the car, which they can. Let's start right there. But it's not me would be a starter, and you have the burden of proof. That'd be one way to go.
Yep.
Then but if you go that route, it's really hard to argue, the car went out of control and wasn't responding, because you need to testify that you were driving in order to say that.
Yes, but this is sort of the similar thing with the Summers case, is he's too stupid to know how to argue in the alternative.
Yes. And I wouldn't argue in the alternative, although it's something you can do as a matter of law. I would not argue in the alternative to a jury. I'll argue in the alternative to a judge all day long.
Yeah, but you need to pick one of those. I mean, maybe what would be an argument to try and get these down to like a manslaughter? Maybe severe emotional distress after the fight with their girlfriend caused him to be focused on that as opposed to the people that he was plowing into. I that's kind of the best I was able to come up with. I don't know if you have a better idea.
Yeah, the problem is
at least
he's just got nowhere to go, and all of his theories are different. So he won't say who he is. You can go with the generalized sovereign citizen. The sovereign, if you're going to do the overarching, he isn't wise enough to say this. He's saying you cannot have criminal prosecution as a matter of law.
That's basically his argument.
As a matter of my interpretation of law, nobody can ever be prosecuted for anything.
Right.
Because everything's a corporate fiction and it doesn't matter, and the entire system doesn't work.
Well, we know
it's a horrible argument. But I will say this, it's consistent in the sense that if you buy it, criminal prosecutions are not real, is the sovereign citizen defense.
Yes.
I will give it this. It's insane. But if you buy that premise, yes, it gets you off.
As it would anyone on Earth, and we could never actually criminally prosecute anyone for anything ever again.
I've been... Oh, here we go. We got stuff. I hear Goofy already. Oh, and our sweet judge. Judge Darrell, good morning.
Can you just make 2 copies of that?
Ooh. Morning fun. Love morning fun.
Guys, I'm not engaging with the ginger stuff anymore. You can keep going, but I'm just gonna pass.
Yeah. I actually agree with that.
A little bit.
I'm right there. I still like her, but certainly within her discretion, but not what I would allow.
Each. You give 1 to each party. Thank you.
I wonder what this motion is.
Peggy, I put you on the no notifications list. He can and he will, I'm sure.
You can, Sam, go ahead.
Well, that's the thing is usually you don't object to
call the
opening
case.
statements, but this is going to be one that's
Do you
very.
need something to talk to him for a second? Yes. Go ahead. You can turn the audio off for a second.
Oh, thank you. Australia in the house. I love my Aussies. For reasons I'll never understand, John, the Aussies have been super supportive of me. I don't know why. I've never been to the country. I'd like to.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances,
Now
please?
there's a defense.
Leslie Basie and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second. Make sure I have everything since Dave's kind of late today. I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
Doesn't dispute the facts in the charging
All right, thank you. That
instruments.
is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about 1.5 pages. I thought it would be helpful to provide to Mr. Brooks as he
It'll never end.
puts
that, John.
together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement
Stop encouraging the mic.
that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening
I love
statements or closing arguments. With that, I believe
For the
there's-
record, is this
I love that you think
what you're referring to? This
the 1.5 pages is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
okay? I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why
I
that's
wanted to make the
relevant.
record clear.
Not a bad idea.
So I appreciate you
Not a
indicating to
bad
me
idea.
that you're aware of that.
We
Even
might
though
need it.
subject matter jurisdiction has not been proven on the record
Oh, God.
and should
Sir,
be
it does
addressed.
not need to be proven on the
It-
record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject
Our world frightens and
I'm just advising you, you cannot reference that in your opening
I mean-
statement.
that was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic, then. I believe the state has
Should be
filed a
proven for the
motion.
By the prosecution.
Oh, he's gonna get
Objection is noted.
I don't think
It
she
is
has
not
patience.
legally sound. It's overruled.
It's definitely legally sound.
All right,
Has yet to be
Attorney,
proven.
I'm going to turn to
This does
Attorney
not
Upper.
attorney to
I
the
believe
judge.
they filed a motion this morning. Has it been pulled through?
Definitely
I probably
legally
just need to
sound.
refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
Oh, thank you.
Um,
All right, go
I
ahead.
didn't-
You can make.
Okay.
let me
I
just-
didn't look at the document. I accept the accept for value, return for value, the document. I didn't look at it.
Give us a report.
I
That
don't
would
know
be
what I'm
interesting.
supposed to say to that.
All right, well, Attorney Upper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
I think that's
All right,
perfectly
thank you.
reasonable.
Any position on that, sir?
Yes. First
We
of all,
love
for the
having
record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point.
our world frightens and confuses me. My primitive mind can't grasp these concepts.
Reference to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir.
I think so.
Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there's no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1, and State versus Gerard, 189 Wisconsin 2nd, 505. The first of those two cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information. And this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same,
Of course you do.
the same person is scheduled to testify again. What if something changes in the testimony?
Learn law.
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
What you're looking for is something called impeachment. You will not understand in
I'm
time.
not gonna
Don't
answer
worry.
that, sir. Can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that
Makes
then.
no sense.
The
It
state
makes no
has
sense,
not
yeah. To
rested
someone who doesn't know
yet.
anything, it makes no sense.
Will the
You're correct.
state anticipate calling any other
These
witnesses?
advisory opinions have only been outlawed
Yes, Your
since,
Honor, as
the
indicated yesterday,
Constitution.
we do intend to recall Detective Casey.
Yeah, made a lot of sense to John and I. We've heard all this before.
Make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury on the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection
Exactly.
of White Rock and Maine. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Maine with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role
A non-Ginger
at the
John
parade.
comment.
So we are, we have been very efficient in our presentation. I believe Your Honor
Yes, you
would
have.
agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
What scares the hell out of him is he doesn't have notes on that.
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls,
That's what recalling
Detective
somebody
Casey
is,
was
you idiot. It's too early for this.
testifying for quite some time, to the point that we actually had to have a
Good
break
Lord.
before I can cross-examine Detective Casey, if you recall.
You get to
He was
cross
up
after
there
both.
quite
It's a
some
cross
time.
again.
That was more than enough time for
No, the issue is that you're
any other foundations to be laid, any
and you don't have
questions
notes.
to be asked at that time. And also,
Too early.
from my recollection, he was asked to be excused.
Say a word. Oh, and go ahead and put yourself on mute now.
Essentially having him start off and then end it,
That's what we need.
I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered.
You need a Judge Manning
And essentially
pretrial
what-
treatment of the
Too
situation.
early for this.
What more could be gained by a second testimony from Detective Casey? What more could be gained that hasn't already been learned? We learned about
She literally
It
just
was
explained that.
vehicles and identification by numerous witnesses.
The prosecutor just
We've been through
explicitly
the,
said this.
the
Yes.
inspection of the
Exactly.
I made a
vehicle,
compelling
we've been
case.
through DNA analysis of the vehicle. We've
Yeah.
been through numerous things in regards to the vehicle.
Yes.
Even the
Yeah, that's
Even
that's
the,
that's nice.
reconstruction.
That's a nice touch.
Testimony. We've been through all of that. Seems like nothing more than
Oh
to get
God, like this one
extra
might break
questions
me.
answered that could have been asked from the get-go. As seeing as how he was up there
We
for
haven't
quite
even
some
gone
time,
to
and,
its
and none of those issues were
stupid
raised at
opening.
that time. What would be the significance at this point? When it's essentially, I should be already presenting my defense at this point.
You didn't say the cat jumped on his wiener, did you?
She was excused from
I think that's what he's got to go
the
with.
subpoena.
I think that's what he's got to go with.
Oh God.
Thank you, sir.
Relevancy.
Thank you, sir. The
Thank you,
court has
sir.
discretion under 90611. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role
Indeed.
subsequent to the initial contact
Oh,
with
thank
Mr.
you.
Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims, In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing.
There you go, brother.
Admitted
You're getting support now.
Court is what she has, so that we can clear that up before we actually arrest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about the last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
You cross-examinate. Boom. Cross-examinate is our word of the day.
To my cross.
Oh, God. Oh, my God.
Cross-examinate t-shirt.
Depending on where we go, if the questions deal with what he testified to previously, it's primarily to cross-examine.
Next Amendment. You can do it.
Based on the new
Doesn't
testimony.
mean you should.
However, 90611 also says this: witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate.
Yes, you're limited to the scope of the direct examination, but he does not understand that. So she has to try to explain it to him.
Too much back into the previous testimony, but
oh God,
no, it does not go back to the previous testimony.
Earlier testimony may come into play.
It can be non-duplicative. You can ask him about the scope under the scope of the part. Oh,
that's
God.
fair, sir.
Also, really quick.
Really quick.
I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was
pretrial offer.
Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I'll put together, started to, I won't say it's completed. That wouldn't be fair to say. I've put together or started to put together a counter offer. So I just wanted
counter offer.
Putting that together.
I threw together a counter offer for my jail cell. Oh yeah, we'll get back to you on that.
If and when you
murdered 6 people,
provide that to the state.
Yeah,
please
I don't
let me
think
know
the
so we can
prosecution's
go
interested.
God almighty.
Not then we'll have the jury brought out.
We do have one last.
This isn't like
large
running a
matter.
stop sign and turning into a jaywalking violation. You murdered 6 people.
The other day.
All right, go ahead since the jury's not here.
We get it early gem. Early gem. Thank you.
Oh, God. Yeah, what's your counter offer? 2 life sentences instead of 6?
All right, we're gonna squeeze it in while we can. It's time.
See, I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
There's no reason. There's no reason for the throuple. I can't justify the throuple, but there it was.
Oh, God. We're off to a
That
great
is
start.
interesting. He'll refer to himself as the corporate agent for something, is my guess.
He is the intervener and the settler for the person known as Darrell Brooks.
All rise.
Aren't we all?
Killed Futurama.
I believe that's Attorney Messer, greatest GAL in the history of GALs. I do not know him personally.
You got to pull the
Thank you, everyone.
Futurama.
Please
I
be
don't
seated.
think I want to live on
Good
this
morning,
planet.
ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here.
If you have to ask, I mean,
At
seriously.
any time that temperature is too cold for you, let me know and we can have that adjusted.
Take the word couple and
All right.
add.
Oh,
Attorney Allen,
yes.
you may call
We
the
can
next
cross-examinate
witness.
for
Thank you,
analyzation.
Your Honor. The
It's
state
gonna be a
would
day.
recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the
It's only
witness stand.
10
When you
o'clock.
get there,
They've
please
been on
remain
for
standing.
15
Raise your
minutes.
right hand, and Teresa will swear you in.
Oh,
Do
God.
you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Allen.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
So my private info.
It's exhibit number 15.
Thank you.
Oh, God.
And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead
He'd
detective.
make a fortune for his commissary.
Were you the
Cross-examinate.
individual who
that's
created
a
this
beauty.
map, states
That's a
exhibit
beauty.
number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection
Nah,
Overruled.
That's
No.
certainly not a prejudice against him.
Yeah.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents.
Had to spiff you up, put my ascot
Some of
on.
the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on. There's been an objection. It's overruled. And the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't
You'll get there. We'll see.
from. You know, and unfortunately, I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled. Foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were
That actually wasn't an
leading
open
this investigation, trying to identify victims. What was the importance of the SUV in the injuries that were caused?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We exclude those.
Overruled. The detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, they were.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right.
Actually, it's not
I'd
about
like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32? You said
Yes.
32? Okay, thank you. Sorry, I just missed it. Just to the witness or published because it's been received.
Yes, we are going to publish this, Your Honor.
True enough.
Go ahead.
Yes.
Permission granted.
Yeah.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it
Yeah.
either.
I can see it. The witness can see it.
Mhm.
Go out it. Thank you for letting us know, sir.
Just the front tables, back tables on, Your Honor.
Hold on. Stop source first.
I don't know what he's on about.
I guess there's a technical issue that it's not coming up on his screen.
Ah. Okay.
I know. Anything? Yeah. You can see it on the screen though, right, sir? On the, there's screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here because
I understand.
It's
We'll
better
get
on here.
tech guy over here to
God.
look at it, but it's previously been received. And
It's early still. It's early.
Other monitors.
what a
So for
jerk.
now, we're going to continue. If there's anything new, I'll make sure to pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled. It's foundational. The answer may stand.
Morning, Kurt.
Do you know if there were other people associated with the extreme dance team that were injured?
objection, speculative.
Overruled. He may answer.
Yes, I do.
And do you know the names of these people?
Objection, hearsay.
Overruled. He may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer.
Speculation.
Overruled. He may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes.
I will
Okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
to relevancy.
Overruled.
The bailiff
They
confirmed it's
they
on in
didn't
the
do
jury box,
anything.
Your Honor.
Thank you.
All right,
Why are you
please play.
objecting?
From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's a minute 23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection, speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection, leading.
Overruled. He may answer.
I'm going to draw one big circle.
Okay.
It has two individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
Okay. A little hard to see right now, but as they
Very hard to see.
as they walk, could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection, speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading.
Mitchell,
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Did you know Mitchell's approximate age?
Objection, speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection, leading.
It's foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
That's a little iffy.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection, leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
are IT experts. Hopefully I can get this figured out.
It's a lot of pressure.
Go ahead.
Could you put something on the screen that's okay to you for the moment?
Next one will be 132 if you want. Oh, I'm sorry, 55.
It's on our screen.
It's on now.
Hold on, let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's
I'm
on,
shocked
it's on
he
mine,
acknowledged
it's on
that.
the witness.
Yeah, I thought he would have fought
All
that
right.
tape.
Just
He would
like
have
in
nailed the
real life,
entire
you call the help desk and they show up and now it works, yeah.
Jury monitors were working. It's not, hold on, let's make sure. It was just working. There's a delay. It can take 30 seconds.
What do you say this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted, overruled. Go ahead, Attorney Alford.
Detective Casey, Exhibit 55. Can you see at the end of the road there or the top of the screen what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection, leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital?
I think that was foundational.
Objection, leading.
Sustained is to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen exhibit 55 before?
Yes, I have.
Are you able to identify Ms. Hospital, I'm sorry, yes, Lola Hospital in exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in middle of the road.
I don't like when they do that.
Nancy's
When they
Granny's
slow it down or
All right, go ahead.
change
Thank you.
the zoom. That to me, I just don't like it.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the Dancing Grannies and hitting Lola Haspel and then striking 2 other Dancing Grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury.
I believe he does.
This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Seriously, that is awful. It's
Sir,
all
do you
awful, but
recognize
that is
the
specifically
item
awful.
shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but
I
I'd
imagine
like
there's some people in
to
Wisconsin
tell the
that
jury what you remember of these items, please.
Objection leading. Form of the first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
God.
Objection to an attack. I think that's a
Oh God.
disparaging remark for the record.
Shut up. Just shut up while this is all this.
Objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What
Mostly
did you
with
determine?
alcohol.
There's a thing called
I determined that they were the jacket, hood, and hats that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
Why do you think we have the highest
All right, go ahead,
alcohol
please.
rate of any profession?
It's 177 on your screen, sir.
Yes, it is.
And what do you see in Exhibit 177?
Objection leading.
Overruled.
I see 2 dancing grannies carrying a Milwaukee Dancing Granny sign And the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177?
177, yes. Go ahead. And if the jurors will let me know when it's in the jury box as well, please. All right, thank you. It's there.
Oh my God.
Again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection leading.
Overruled.
They do.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection leading.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there have been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay.
If this is giving us that impression,
All right.
imagine what's
Do
doing
you
to the
see,
story right now. It's
Exhibit 150.
compelling like you would
Yes,
have
I do.
believed.
Please describe what you see in Exhibit 150.
Objection leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to?
Objection. This is
Overruled.
in prison for the rest of my life 6 times over.
Exhibit 150 is received. Permission to publish is granted.
Thank you.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
It's okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only, number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I'll call this States and they had 140 exhibits. How do we get this many?
Keep going, Attorney Younger.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection, leading.
Overruled.
Just shut up.
EP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
Go ahead.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called their name and misleading the witness.
Overruled.
Seriously, I'm losing patience with this.
Yes,
guy.
we have.
Could you describe this video for us, please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Is this the rap video? And I'm being serious.
I genuinely do not know.
Somebody sent
Please
that to me.
Identify 175.
This is
relevancy.
Overruled. You may answer.
And thank you, by the way.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed.
Yeah, that's exactly right.
What is the source of this photo?
Objection, leading.
Overruled. The witness may answer.
It's unbelievable.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This
is
is
a rule to sustain.
Overruled.
He said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry, I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
John and I
This is a screenshot taken from a video.
might need wall punching breaks.
Move to admit 175 and permission to publish, Your Honor.
And again, we see awful shit on a regular basis.
What's the relevancy?
But this is
I don't see the alleged
beyond the pale.
This is next level.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors.
Is she gonna play this thing?
I think she might just use the still for the license plate.
All right, go ahead.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection, I don't consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading and speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
Forget the first part.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some
That's the
reports.
point. That is a fantastic final witness.
When the vehicle was found on Maple Street, you weren't there.
Correct, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. Just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Yeah, I don't want to talk over this.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted, overruled.
How did you get it?
Agreed.
Objection, leading.
A good point, Pat.
Overruled, the witness may answer.
You just stated, I got it.
Yeah.
Overruled, he may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department secure storage facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked
Thank you.
the vehicle to see if the key would work in the car.
What did I say 2 days ago?
Objection, leading.
Overruled.
Make sure the key matches the car and you're
I found that
done.
the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name, misleading the witness.
Overruled, foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Good question. And actually, no, I don't know.
Yes, I have.
I don't either.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name, leading.
Overruled, the witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what's the relevancy?
Overruled. Go ahead.
Grounds for overruled.
Relevant.
She was by the other day. Yesterday we had Natalie Wisco. Day before Natalie, lawyer
To the
chick.
counts alleged in this case. Go ahead.
Can you please identify Exhibit 88?
That's Natalie's
sir?
over, but
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
so this should be the last couple of questions.
Overruled, the witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
Overruled, the witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled, the witness may answer.
All the charges that I see in here are felonies.
I don't think
To
he
your
has
knowledge,
notes
was
on
this
this
bail
cross,
in full
so he's
force and
got
effect
to
on
be
November
running forward.
21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
Like to display for
We've
the,
already speculated to. How's that coming into evidence?
Yeah, he might blow today.
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your Honor.
Oh, all right. Turn that
I
on.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Hopper.
Thank you. I'd like to display for the witness only exhibit 89.
She's saving all this for close.
Go ahead.
Sir, can you please identify 89?
And if what we saw in the last hour or so is just a taste of what they're going to put up on close,
Overruled.
oh my God.
This is
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled.
Strawberry.
Go
Strawberry.
ahead.
This is a bail bond through Milwaukee County Circuit Court
I don't need you.
for Darrell
thinking of
Edward
it.
Brooks, the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in exhibit 88?
Objection, leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection, leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection, leading.
Overruled.
States 11/11 of 2021.
That's actually a good question. What is the relevance of these prior bad acts?
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection, leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection, speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Okay,
Thank
yeah.
you, Kathy.
Finally, sir, I'd like to
Kathy's just a big
put up one
sweetheart.
last item for you, or 2 items. 1 second.
And thank you, Courtney, for pointing it out to me.
I'd like to display for the witness only exhibit 13.
We've got Kiwis, which is awesome.
Yeah, if I were defense attorney, I would stop this one.
Objection, what's the relevancy of this? How does it say any foundation?
I get that it's about prior bail jumping, but
Testimony.
it's not relevant. And
Well,
again, 2 prior incidents doesn't
give the
necessarily
state some leeway
matter.
to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell
We
if
can play that
exhibit
at the
13 is a
break,
video,
Amber.
sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection, leading.
Overruled.
Still relevancy.
I think my hair
State
color
is
has gotten you
asking the
almost
foundational
$100.
questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Hopper.
That's all
Yes,
we
I
got
have.
to soften this hell right
What
now.
does this video depict?
Objection, leading.
Overruled. The witness may answer.
Objection, speculative.
Overruled.
Love it. Love it with UK in the
This
house.
video depicts the backyard
Marlboro
at 2014 North 19th Street in the city of Milwaukee.
You know what's in the UK?
That's the
Ireland.
address of Dawn Woods, the mother of
Fuck
Darrell
you on
Brooks.
that one.
And on the
Land
on
of the
lower
ginger
left-hand corner,
deniers.
you can see a Ford Escape.
Ireland is its own
In the
free
lower
republic.
right.
They didn't fight a revolution for that for nothing.
Move to strike that out.
Well, there's that. Okay. I'm American. Don't expect me to get it right.
The objection's noted, overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection.
Love it.
Overruled.
Yes, I do.
What does it say?
It says 11
Love it.
/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it mean that the video was taken on November 21st, 2021 at 1:26
You
p.m.
sure do not.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection stated.
Sustained, if you could lay a little more foundation.
Sure. How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Making you a damn fortune.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection. Relevancy.
Overruled. The witness may answer.
Thank
Yes,
you.
she was.
Do you know if the video was provided to police when asked?
That looks suspiciously
Overruled.
like more UK love. Thank
Yes,
you.
it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection. Relevancy.
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on. Don't play yet.
Yes, if the jurors would let me know when the
I am like the
monitors
chillest
are
person you'll ever meet
displaying
until I go into lawyer mode,
video.
and then things get serious. But
All right, go ahead.
Do we have him going over the fence here? No?
oh, that looks like the car. Maybe that's where he ditched it.
Yeah.
Why are they continuing to run it?
Wait. Are you getting into John's shirt now? I've got a freaking Scooby-Doo ascot on right now. you have the temerity to get after John for wearing a blue shirt? I love it.
Detective Casey, were you able to see
my
any
old,
emblem
yeah,
on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection.
Okay.
Overruled.
Gotcha.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the.
Yeah, just to the witness only, please.
Thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay.
Yes.
I believe
Move to admit
so. I think this is
14
the
and
last
permission
witness.
to publish, Your Honor.
Objection. Relevancy.
The objection's overruled. Exhibit 14
They're
is
ending on a hell
received.
of a
Permission to
note.
publish is granted.
They went chronologically, and then they seem to be mopping up foundations to set up the
Sir,
close.
do you see Darrell Brooks in this
Makes
photograph?
very good logical sense to me.
No, very, very meticulously well done.
Noted, overruled.
Super
Yes, I do.
professional.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's
I
not in
sent
the
him a
jury
link.
box yet. I'm sorry.
You can state your objection though. Overruled. The witness may answer.
Mr. Brooks is wearing a red T-shirt, blue
The point
jeans.
is that there was no damage when he picked up the car.
Colored flip-flops
and then
on with white
what do you
socks.
think caused the damage?
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
Yep,
And
that's a
that's what
clean
time?
baseline of that vehicle
In,
prior to this mess.
On the 12-hour clock.
Yeah.
Overruled.
That would be
I might
1:26.
refer to it as a mess. It's a murder.
All right, thank you. Have any other questions, sir?
We cross.
And the two exhibits we just watched, 13 and 14.
I thought it was going to be helpful when it started,
Do you see anyone driving the vehicle?
but no.
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
Oh, God.
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle. Because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
Ugh.
I object, Your Honor. That was the question, and he's already asked and answered. The question is, anyone be seen?
So there's that.
Objections. Not sure what the objection was, but the answer may stand. You can ask your next question.
It was asked and answered, Judge, but whatever. It doesn't matter.
Just go back to exhibit 175 and pull that up.
Prosecutor smacked him, made her point. It was good.
Would the state please pull that up? Witness only or published?
Published.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
What is he publishing?
You know John's my boy.
Why would he publish that?
All right,
Just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
No, but
So
there's a
how
whole
do you know
video
who
where
it
they
is?
can see your ugly mug, the rest of it. Okay?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other
That's what
exhibits
we're here
that
for.
can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only
There's that as well.
exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
Oh, good Lord.
From
I didn't
just
hear
looking
that,
at
but
this,
probably.
no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this
Didn't
moment.
they introduce the whole video?
Strictly that.
Could you ask your question, please?
I'm going to object as
She
an
didn't ask
answer.
to publish it
Sustained
for
as
some
to the
reason
form of the question.
at this time.
I think she's
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Maybe they play it on
Thank you,
redirect just to show what an idiot he is.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could
We
limit.
will at some point,
Perhaps direct him to a specific time
I
frame
believe.
regarding the use of the vehicle.
At the time of the incident?
I'm wondering if they're letting him
Yes.
go and then
And
play
what,
it on
and can you clear
redirect.
that? And what information was that?
Freaking liar.
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but.
Did you see the video in its entirety? The video that this exhibit came from?
Yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
That is possible.
Ever inquire about the identity of this individual?
He was represented, so they might have done motions in limine, but I don't think so. He certainly didn't get it done by himself.
Circle.
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now,
So many t-shirts, so little time.
that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to exhibit 13. Published.
He's got us now. He's got us right where he wants us.
Go ahead. The state would assist, please.
Is this the
13.
culmination of his four-dimensional chess right here? Are we about to see it?
I'm genuinely wondering where he's going with this.
Can you
So is he.
play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
They could redirect the witness
We're
and
gonna
play
wait
the damn
for it.
video.
Oh,
I don't know if they. I
That's
think
what
they
I'm
want to
thinking
save
there.
it for the end for impact.
Yeah, I'm wondering how they want to use that.
Okay,
They certainly
go ahead.
can lay
Thank
the
you.
foundation for it. Again, unless
Doesn't
there's a
matter.
motion in
49
limine on it,
seconds
which I'm not aware of.
I don't think I'm gonna need the. Well,
I
I don't
don't
know.
know one way or the other.
But even if there is, he's opened the door now by blathering on about it in his
Pause.
while he cross-examinates.
Right there, the individual that you observe. Right here.
Yes. Nailed
Do you
it,
see
Amber.
them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see
Wearing
a
a red
hoodie anywhere
t-shirt.
present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle,
He's going to
it'd
foil
be
the
fair to
ID
say that you can see the front,
because he wasn't wearing
very
the same
front end
thing.
of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Where at the time that we're looking at right now?
God.
No, idiot.
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
You're walking to the driver's side
I'll
door.
allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down? Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Why?
Same exhibit 13.
All right.
Why?
The state would put that back
Right.
on display,
It does-
and there you go.
Do
Do you want any
Right.
more of a plate or just the still?
we waiting for the jury or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
Oh my God. That's
In
where
the
he's
photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
No, it's
That is
not
incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle,
Didn't
I mean,
investigate based upon a picture,
strike
you
that, not the
idiot.
vehicle. I'm still looking in the corner right here.
Oh dear God.
From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see the address posted in this photo.
It's the back of the house.
Judging by this, well, actually, it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video,
Hold on. You have to let him finish because that was not the question you asked. You asked him how
Oh,
he knew. He can answer.
It's a responsive answer, and it's
Go ahead.
not helping your
Absolutely
cause.
responsive.
I've been at this
Not
address
good for you.
before. I've spoken to your mother. I've been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
you recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
Who cares?
I believe that I saw the video
Just leave the
first,
house.
and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was.
But now he does.
Now he does.
That would be an incorrect statement.
You just said that you saw the video first before going to the house.
Who
Or
cares?
did you not say that? That'd be
Normal
fair to
human
say.
beings can integrate two pieces of information.
I guess I'm a little
together
confused in your
and draw a
question.
conclusion.
We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for
I
you.
follow you, but that clarification wasn't stated before.
Yeah.
So
Oh, sweet Jesus.
clarification of how you just clarified it. Can you clear the
Are you
circle,
done with
please?
this exhibit?
Yeah.
You take it down. Thank you.
Thank you, Bill Fox.
You made reference to the key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
Okay.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I worked with for a long time, and I trust what they tell me to be accurate.
Extremely high.
You made reference to there being a couple, what's the word you used? A couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the
Really is.
fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had.
Please
It was
give
just
him
kind
a
of
reason to
being thorough and
explain how we
verifying
found
the
multiple ways
person that
to
we had and
identify.
the name that he
Good
was.
job. When you're arguing a mistaken identity claim, Jesus Christ.
It'd be fair to say fingerprints are pretty accurate, though, correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't
Thanks,
be
Betty.
any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
It's not compound. It's
Sustained
not
as to the
difficult
form of the question, sir. Please
That was
rephrase.
very clear.
Sustained as to the form of the question.
And Where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee Falls.
Whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question.
You asked the question, idiot.
Right.
His answer may stand. Your request to strike is denied. And the
He's
witness
giving a
may
responsive
continue
answer.
answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence.
He
Erica
reiterates it.
Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Agreed, but they chose him. I don't know what to tell
Why
you.
would you go all the way to Iowa?
Sometimes you live with your decisions.
Because initially you listed her as a witness on your witness list
Of being on the
court.
screen.
So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr.
You
Brooks, you can't
subpoenaed
testify
13 people, including the state of
at this
Wisconsin.
moment. You have an opportunity should you choose.
I just wanted that clear for the record.
And you
Since
let
what
the
was
Can't be
said,
struck from the record at this point because you're attempting to testify. The
I'm not
jury will
attempting to
disregard
testify.
that.
I just wanted the
Yeah.
record to show
The
that I
jury
had no
will
knowledge of doing that.
It's also wrong.
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous.
It's ridiculous.
Clearly,
So you said you went to Iowa
not in the way you think.
to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
The only one I know would be from the movie Airplane.
Was that an attempt to prepare for what might have been said?
I'll allow that. Okay, go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
God almighty, it's not even 11:30. This is going to be a long day, Mike.
So you made
Aren't they all?
reference to not being any surprises.
What's the goofy look for?
Would it be fair to say that there was a little worry there?
That's
Objection,
discovered.
argumentative.
Grounds.
Sustained
In a
as to the
civil
form
case,
of
you get to
question.
depose the other side's witnesses
What,
before you
what
put a
surprises
trial.
were you referring to? What do you
It's
mean
not
by
a
surprises?
complicated
No surprises.
concept.
Your Honor, I object to this
We
entire
don't
line
do
of questioning.
trial
The
by
witness is Not
surprise.
expected to testify. It's wholly irrelevant.
God.
Look, he opened the door by putting the name on the record and saying where he went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
No, it's an
We
ancient
wanted to make
Chinese secret.
sure that there wasn't any
We're not sharing
information that we weren't aware of that may come up later that would be helpful in the trial.
Okay.
Oh, good Lord, you might be right.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as to, next question, please.
Reason for the sustain, Your Honor?
Not
The
relevant.
reason for the
Well,
sustain.
the question was asked, does he recall?
How's he supposed
Sustained,
to
next question. please.
cross-examine it if
Grounds
she's
for
going to
sustain
sustain all
you.
the objections?
How's it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevance.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is.
Sir, move on, please.
You don't object to an
90611.
objection.
Also not
Jesus
relevant.
Christ.
Assumes
Very
facts
well.
not in evidence.
It was a tricky move.
Say a word. Oh, and go ahead and put yourself on mute now.
And in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal.
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial ruling.
Okay.
During the normal course of an investigation, we do background
Actually open the
on
door.
a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
I'm thinking they're high. I have no reason, but I'm thinking they're high. Just because he's that stupid.
And in reference to
He can't be that stupid. I mean, he's very, very stupid, but dear God,
Charges
can
in
you
one
imagine
county.
that cross?
and potentially being charged in another county, in reference to that.
Looks that way to me.
Like I said yesterday, call him the locksmith because he's opening all the doors.
Wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
No, you could be extradited to another county.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
Oh dear God, is that where he's going?
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge. Legal
What for a
conclusion.
legal conclusion?
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
I'm getting to the
Correct.
point where I might need to take a walk for a minute.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habonic.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also, because I was at the parade route a little bit earlier and I had the most information out of anyone, it took a little while for the other staff to come in. So I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
Yeah.
And that would be
did drop that,
the
and I liked him
information
for
that
it.
you said you had more knowledge of than anyone else at that time. Would that be
I don't think I would have the
in
composure.
reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
His questions are making the witness seem more and more credible.
When the vehicle first entered in the parade, what do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
the vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection, speculation.
Sustained. Calls for speculation.
How is this helping you, you idiot? You're
Do you
admitting
know
that
why
you
the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
You're absolutely right.
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure that the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it'd be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name.
Did you know who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold on. Compound question. Ask one.
Not
I was
quite
just giving
yet.
clarification of no.
You
What I
need
meant
to,
by
it's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
She just gave them to you, idiot.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object.
Grounds.
Grounds.
Good Lord.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
Yes, I'm a
So
human
would
and
it-
I make observations.
Would
Mhm.
it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection,
Grounds,
irrelevant speculation.
grounds.
I'll allow it based upon his training and experience. He may answer.
It's a possibility.
Good answer.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself
You're doing a fantastic job dealing with this
have
moron.
been present for all testimony. Would that be fair to say?
That is not correct.
How so?
Prosecution witnesses have
I
been
was sick one
awesome
day and I was
across
not
the
here.
board.
Well,
absolutely.
I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of,
This is the kind of detective you genuinely want.
and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of
Nobody
4014
knows,
North
including
19th
him.
Street. That
Nobody has the
testified to
slightest clue.
obtaining the ring footage the same night. Were you aware that? Well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working.
I
They
do think
spoke to
that's the
her,
theory. True.
and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And
Even better. It
were
was by
you there
request.
yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
So is he.
I don't recall
Very
the
first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds.
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The investigation continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know. I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms. Woods multiple times?
Because every time we spoke to her, we got different information. And at that time, we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
He literally just kicked open a door without realizing it. Oh my God.
You made reference to
the law talk with Mike Chad is all over it.
He's straight up undoing everything that his defense attorneys did for him in the motions in limine and pretrial evidentiary rulings.
He unraveled it all right there.
To your knowledge, were any of those charged?
Oh God.
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
He's not a lawyer.
Sustain the objection as to the form of the question, if you could please.
Oh my
rephrase.
God. It's not even noon. Knock, knock, open up the door. It's real.
I'm gonna go a different route. Do you recall?
In fact, it's almost noon where John is.
Do you recall serving
We're getting close.
a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up
Yes.
at a later point if need be.
Right in line with that.
Yeah.
What was the warrant pursuant
He
to?
literally is
Sustain
undoing
the
a
objection, that's
preliminary
topic.
motion
He did answer.
to try and exclude
I'll
evidence.
sustain the state's
and he's just
objection.
blowing
and
that
directed
wide
him not
open.
to answer. We'll take it up separately.
Kelina, that just means you're paying
I'll have you
attention.
continue with your cross-examine. I'll take it up later.
Mike doesn't share. You got to know that.
Oh, Christy, yes, thank you. That's very generous. Jen will get nothing and like it.
That apparently is the fate of millennials these days.
Just means you're gonna have to go over, subscribe to his channel, and super chat him there. I recommend it.
If I could ever get to 4,000 hours.
You're killing it with trial by combat. You know why? Because you have a
Made
thumbnail.
reference to
Thank you to whichever one of my viewers made a thumbnail for me because it's
driving into
awesome.
the
Oh,
state
he's
you
the
were not
best.
injured. Did you
We've
file
been
a claim
touched.
in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
No, don't feed him. Don't feed
What
him.
the claim was?
Don't do it.
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their
No, don't go down this
particular
path.
insurance companies?
Please.
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Yeah.
Is that the answer?
Yes.
He answered it twice.
Oh, God. I think he got out of it.
Thank you.
I
I think the witness got out of the stupid because he's
As lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things?
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I would
I have no
say
direct
that
knowledge,
oral source
but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
How's that for you, monster?
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
Agreed.
Amen. I actually think a relevance objection here is appropriate. you're getting very close to collateral source
It would
information.
be fair to say that
I
you
know it's
worked
only civil, but in principle,
extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it extremely.
God, could he be any dumber?
I'll answer yes.
It's your word.
I mean, it's a 3-syllable word, Mike.
It's asking
We know
the
he
answer
doesn't
too.
understand those.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
There you go. Bolster his
And
reputation.
are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Nailed it.
Sustained is to the form of the question.
Are you the only detective directly involved in the investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
He's almost making an argument. And I know I do this all the time, but I'm trying to find something legally
So would
interesting.
you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
He
Grounds.
does this where he gets close to an actual legal
I just
argument.
want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. Is it not relevant?
Mr.
It was
Brooks, next
sustained.
question, please.
Nobody knows who
It wasn't
he is.
sustained.
That should be known. Nobody should
It's
know
not
that back tape.
relevant to
I
the
don't even
issues
have a
that
back
the
tape.
jury needs to determine. Next question, sir.
I don't know if we can get through
Action.
this trial
You're
without
telling
each other, Deanna.
I'm assuming that's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will. So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Oh, dear
Okay,
God.
at
That's
least
the way
we
that
know.
works.
And who
No,
would the
no,
plaintiff
your
be in this
argument
matter?
would be impeachment.
The state of
Jesus
Wisconsin.
Christ.
Is that an entity or a living human being?
It's an
That
entity.
you're watching the other
Okay, entity
testimony
file
and
claim.
therefore
Objection,
Grounds.
legal
Some of your-
conclusion.
Grounds.
Sustained.
God.
You are aware that only a living,
All right,
breathing
I need a
human
minute.
being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You
move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the
It
end
was
is
this close to an
irrelevant,
actual
argumentative,
impeachment argument.
calling for a legal conclusion.
Objection is not calling for a
The-
legal conclusion in any
The
way.
court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for
Well,
all of the
who
reasons
does?
indicated by the stated, also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's
We
overruled.
desperately do, and he gets close
You
to
do.
them sometimes. He really does.
You want him to trip on
That's a judicial determination.
some sort of argument that you can actually analyze, but it's not going to happen for you, John.
But he keeps getting so close. The whole idea that he was there
Go ahead,
during
Mr.
the
Brooks.
course
Please
of
continue
the
with your question.
testimony, that's an argument of impeachment. Like, there's so many things that he's so close to, and he just doesn't get there.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses.
I want him to
Please.
accidentally make a legal argument.
These questions
She
we
doesn't need an
addressed
objection.
during the initial cross-examination of this
They're
witness.
going to keep coming up.
And
Yeah.
I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
And you're going to keep losing.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
You don't got to keep doing that, Your Honor. You don't got to keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that.
I'm informed.
But it's relevant for the
That
jury
might be
to
the
know the
dumbest thing he
truth.
said so far.
They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Correct.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
not
Not
truthful.
lawful
All right,
law.
under
Law,
906.
we got it.
And now
We need a bingo card.
stopping the cross-examination. Any redirect by the state?
Objection to that. I would like
Noted.
legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take that under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
It might make him
what the rule
do
of
his
evidence
opening from
is.
the courtroom.
Your Honor,
next
for the
door.
record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me see it and I'll
when
take your
did it become an
objection
exhibit?
under, I'll take
It
the
was never an
objection under
exhibit before.
advisement.
Haven't requested that it be
I haven't
introduced
seen
yet.
this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have all the
Opper.
exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits. This was never in it.
I'm sorry, this is comical. This part is comical.
Oh, let it end, please.
All right, you can stop.
The judge is like, I literally don't know what it is.
Sir, do you
I'll evaluate any objection,
recognize
but
what's
I don't know what it
contained
is.
in State's
Nor
Exhibit
does he.
178?
Objection,
Overruled,
relevancy,
overruled. Go ahead
leading.
and answer.
Yes, I do.
What is it?
Objection, leading.
Overruled, the witness may answer.
I'm still gonna object. How is it?
Mr. Brooks, I ask that you
I
honor
have all
the ruling that
I
I
have all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard.
Can you
the
be
statements
explained?
made
No,
by
there is
Mr.
no
Brooks. They're
explanation
not
for you.
evidence, and the state may
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Objection. How does he know that?
Overruled.
Because he watched the video.
The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll find that it's relevant. I'll receive exhibit 168. Permission to publish is granted. For the record.
It's 178, Your Honor.
No,
Really
can you
should
please
learn some
tell me
law.
the length of the video.
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the exhibits.
Just as my chat called for. Let's be honest.
Two issues I still need to
But
address.
how can you play something that's not, that I didn't?
Watch
Mr.
us.
Brooks, I'll
It'll be
take that
awesome.
up
I told.
outside the presence of the
Did I
jury.
not call it?
Your
It was
objections are
in the
noted.
video.
Overruled.
Prove that he's an
Fine,
idiot.
but
actually, Your Honor, I changed my mind. I would like to play the audio, please.
Ah.
this is
All
mine.
right, let's do it. Let's go all
I want
in.
it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So
I
we'll play
called
the
this,
entire
folks.
video, Your Honor, 2 minutes, 33
This
seconds.
is trial strategy.
Objection to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned the
questioned him
detective
about,
about
I
his
questioned him
knowledge.
about the steel frame from the
Knock,
video.
knock, open up the door. It's
The video
real.
wasn't even in the exhibits that I received.
With the constant pop of stainless steel.
I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
So play the sound. I want to hear it now.
I'll address that later.
Oh, what a freaking moron.
It was created out of the blue.
You knew they had the entire video. Oh. This is priceless. I'm so glad I called this. I'm so glad they did. Oh, God.
I mean, he asked for it when he said you can't identify me in the picture.
I know. That's what he
What else are
kicked
they
in the
gonna do?
freaking door.
All right.
And that's what I thought they were hoping he would do. And I'm so glad that they actually followed up on it.
Have it your way, big dummy. Here it is.
There you go. There's your face, asshole. Right in front of the same red car.
And not that you had any, but and just another way to trash your credibility as you go.
Oh my God.
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection, leading.
Overruled foundational. The witness may answer.
Yes,
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Copper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection, leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. And yeah,
Noted. Do you have any
question.
questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That was a question. When
Sustained.
was this
As to the
video
form
made
of
an
the
exhibit?
question,
When was this video made an exhibit? That is a question.
Yes.
Objection.
Was an objection,
Directed
and it
at
was
the witness,
sustained.
Your Honor. It's beyond
Or as you'd like to
his
say,
knowledge.
Well, he said he saw it.
but that's not the question asked. So
You
you
could
can
ask,
rephrase your
when was
question.
this video?
You wanna-
When did you see this
Timestamp
exhibit?
on this
When did you
video
see
in
it?
the metadata?
With the
That would be
understanding that you're
legitimate.
asking, when did he see the video? I will
When
allow
did you
the
see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective
Did
Casey.
you yourself download this video
And
and
I
at
saw the
what
video
time?
for the first time.
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir,
You're the one
can I
who's doing
interrupt?
it.
States directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
never see nothing.
I'm advising both
Don't nobody
parties
never see
to
that.
show
Come on, man,
decorum
this is not fair.
and restraint,
Oh.
to be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection.
Who
Argument.
cares?
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection. Argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection. That's a
Grounds.
misstatement, Your Honor.
Sustained
it was-
as
it
to
was
the
not
form
brought
of
up
the
in the
question
earlier
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked or however you refer
Asked and
to it?
answered.
What would be the need
Asked
to
and answered, yeah. And again, he
view
reasonably decided
again
to prepare for his
this morning
testimony today.
something that you had viewed numerous times before?
I'll stay with my
Objection. Objection. Compound. Asked and answered. Misstatement of the facts. Argumentative.
All of them.
Sustained.
All of them. Yep.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained. As to the form of the question.
This,
Nothing is an exhibit until it's accepted by the court.
Yeah.
That is literally how all of
can
this
you clarify
works.
again why you viewed the video this morning?
Objection asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question.
I gotta clip. You gonna sustain everything?
You gotta clip that.
Next question, please.
I'll have more questions, man.
Find the timestamp. Hang on. I might have it.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information.
Mr. Brooks, I'm going to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not
We're
fair.
trying to
It's not
convict
right.
you. And we're doing a damn good job of it.
The state is doing a fantastic job of that.
You have a seat. Well, once
Judge
the
is trying
jury's
to
outside
make the
of
trial
courtroom,
work.
Trying
I'll
to convict
pick
you
up
for,
the
again,
objections previously
let's
in
never
evidence.
forget, murdering 6 people.
First of all,
With a car. at a
Attorney Howard, you can
Christmas
make a
parade.
record as to
what seems like a very nice
this
community.
exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this
They turned it over to your
Mr. Brooks, I need to make a record, so just please
We'll give it to
sit
you.
down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
Oh my God, you're a toddler.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit. That's
Mr.
why I
Brooks, I
raised the issue.
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
You made it.
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door and it's proper. There's absolutely no surprise to you that that video exists.
Perfect ruling.
And that is my finding as it
What do
relates
you
to
mean by
that.
it's no surprise to me that exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
But with all
So
respect,
go
Your
ahead,
Honor, you're
Attorney Hopper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit?
Attorney Alvarez, go ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well.
Opened the door.
Court is well aware.
He said social
There's
media. He
nothing
didn't say what it was.
Sir,
Counsel got it excluded.
interrupting.
You just opened
We have to make a record of it. You've
Then make the record clear.
interrupted multiple times. I've been abundantly
Make
patient
the record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your Honor.
gonna take that
And
as
just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial.
And I love them for
Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion.
Well, there has here on Law Talk with Mike.
He can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception.
Oh, God.
I apologize for my tone, Judge.
Thank you. I appreciate that additional.
I needed every
record
minute of
being
that.
made.
That was everything I was thinking in my mind.
My previous ruling doesn't change in any way that the exhibit is
I
relevant.
object to that, of course.
I indicated I would take it up because, and I'm taking it saying
that was
withdrawing the
awesome.
request to play the lyrics.
That is correct.
That was an awesome moment.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with possible, was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
Oh, that's cute.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when the statement is untrue.
The audacity of the prosecution.
What's untrue?
Are you kidding me?
He used the word right. He used the word right. I'll give him credit.
He used the word right. That's fair.
Now don't nobody know what I'm talking about.
It was dumb, but
I don't know specifically what you're talking
there's a
about.
reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Yes,
I haven't made any of those observations.
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
They've been so professional.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time.
Maybe they're actually having conversations off the
I
record.
didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are three attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidence.
Hey, what did I just say?
About testimony.
So why is it always laughing?
Which is like
I haven't noticed that other than the one
common
that you
every
pointed
day.
out.
Well, we have cameras. That's what the cameras are for.
Let's refocus our attention on what we're here for, and that's
Okay,
this trial.
I'll take that.
And do you have anything you want to put on the record?
I'm putting it on the record
As
if I get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of
need
any.
legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying
exhibit.
that she can
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of speech.
Okay, so what is it
Alright.
implying to?
But
What would that be implying to?
As
How would
attorney-
anyone?
All
How
right,
would
I'm
anyone in
moving
my
on
position?
because you're not
How
providing me
would-
with any
how would
legal
any-
basis.
I didn't even
for
finish.
me
You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that. You didn't even let me
You're
finish.
not letting me
You
finish.
didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wouldn't get to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with the top of my head?
Yes.
Yes.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do this?
You open the bottom line is you open the door to
It doesn't,
playing
it
of that
doesn't,
video.
we're not talking about
The
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're talking about being fair.
Absolutely.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
that
due
incident.
respect, if I had
Right.
done that,
I am going to move on.
if I had done that, it would have been a big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down and
I don't
be
know what that
quiet.
means.
If you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks.
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking, what do you
Mr.
mean?
Brooks.
Why are you asking her? You just heard
You
what she said.
continue to
That is
come
not,
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking
I
me
don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing it?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying
answer
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me,
think
please.
everyone's lost patience.
I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like
yes or
I don't
no.
like your tone or the way you're talking. I don't.
Mr.
I don't
Brooks,
appreciate it.
We're done.
Sit down. I don't care if you don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
Judge.
for
No, you haven't.
you, and
It's
I don't
absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to make a ruling.
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I think she's at the end of her.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
taking
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes.
How do I know what I'm supposed to answer if I don't understand?
Yeah, I think.
And I don't agree to a stop.
This idiot. Oh my God.
Did she just bang him out right there?
She just called a 15-minute recess. She's like, screw it. I'm not dealing with this.
She made the record she wanted to. Do you want to do this? He won't answer. I'll take that as a no. You've waived your right to question him on that. Let's start out. Let's come back. If the state rests, then opening statement time. Let's do it.
Yeah, I imagine state probably rests. Jesus Christ. This I did not expect the morning to be that insane.
You got to come loaded for bear.
Clearly. Oh, Lord.
You got to come. You got to come loaded on this one.
You could tell. Honestly, I was so proud of the prosecutor on that one because she forcefully made her case in the last 20 minutes or so, and it was awesome, very well done. And dear God, defending the judge, that's always a good look.
Both the prosecutor and the judge, they've decided.
They're at the end of the rope.
I get a lot of this too. Why isn't the prosecutor objecting? Because he does a lot of objectionable stuff, and the prosecutor did sparingly. I think that was wise. I do. Yeah. And the judge has held all this off till this time too, and she actually showed some irritation with him. Not bad, but still way too mild for my taste. But she's had enough of him too.
I think everyone's done with him right now. And I think that they know what's coming. They know the prosecution's going to rest. And he's going to give his opening, and it's going to be a freaking nightmare. So I think to some extent, there's almost like a sense of urgency to put him in his place before they unloose the reins, so to speak.
Well, I think that's another thing from the judge's perspective. I can see I would have had him sitting in the other room the whole time. But it's really hard when he's giving his opening statement or putting on witnesses to put him in another room. That's going to create an issue that he doesn't get a fair trial.
And I don't think that he gets the idea, because I think what they're trying to do is, I think they're trying to discipline him a little bit before he actually is in the driver's seat, which is a really awful metaphor. Sorry. Right. But I think they're trying to give him a little taste of, like, we're not going to deal with your BS on your case in chief.
Well, absolutely. But here's my question. Did we break for lunch? They didn't say. She usually gives some direction.
No, she said a 15-minute break. So I might need to run down to the 7-Eleven and get another pack of smokes for this.
Because when it breaks for lunch, I've got to call and ask Yesenia what I haven't done that I should have. Oh, that poor thing's been working. She's been working.
Oh Lord, this has been
okay. So then run on down there. I'm just gonna hang. I'm gonna leave this stream open until they break for lunch, but I'm not gonna really do anything until they come back. Yesterday it was fun. We tried to go, and then it got even worse when we got over to Judge Simpson's room.
Yeah, well, I'm not going to make that suggestion again. That was kind of depressing.
You're like, well, let's just look at another call. It was a good suggestion. And then usually Judge Simpson, there's something funny going on in the mix at least. And then it was like super serious time. That's the way it is.
All right.
So
I'm gonna
go do what you got to do. I'm leaving this on, and then just as soon as I hear from, I'm just going to turn my camera off. When they come back in 10, 15 minutes, I'm going to turn it back on. Then I'll close it for lunch break and do a new post for afternoon.
All right. See y'all in a minute.
All right, cool. Because they're near the end of trial and they just want the thing done. That's why. I get it. It's frustrating as hell, though. It is. All right, I will be right here, but I'm just going to wait until they come back to get on.
Your world frightens and confuses me. My primitive mind can't grasp these concepts.
Say a word. Oh, and go ahead and put yourself on mute now.
Ma'am, you didn't say the cat jumped on his wiener, did you?
I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Oh, sweet Jesus. What?
25,000.
That's so dumb.
I know, it's ridiculous, isn't it? It's stupid.
Yeah, call me with $2,500. Yeah, you're going
Here,
down.
no, ma'am. You're right. It is crazy. Let's change that. Bond's 50,000.
Oh, Lord.
Hit the camera.
Cut that camera, please, Mrs. Tang, because I don't know what's about to happen there.
I know where there's free lodging. Mm-hmm. Okay, I'm assuming that's a yes. Okay. Mm-hmm. Oh, sweet Jesus. What?
Your world frightens and confuses me. My primitive mind can't grasp these concepts.
the record in State versus Brooks appearances are as they were before. Yeah, let's do that. All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name for the record.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I had one question about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a certified bail form.
No, I'm asking. Oh. I'm asking Mr. Brooks. So,
sorry.
That was the second of the two bail bonds. Do you have a recollection whether it was received?
I don't.
All right, then
I
what
know
was
I objected to it.
I know you
we know
objected
that.
when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just
I
had a
think you
misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what was that? What witness that was?
That was Detective Kate.
Look at that.
Yes, I am, because it was echoing. Darn it. I was just saying, yes, I did call Yesenia to line up my tasks for lunch.
175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175.
We got Venezuela in the house here? I love it.
175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was
All good.
178?
178 was the video.
Oh, that was the most recent one. Okay. What's the
Yesenia does all
request then
right.
as it relates to when the jury comes back in?
Your Honor, I just, there's two different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those
Thank you.
175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
All right, sir, do you have any position on how I address this in front of the jury?
Yeah,
She's a
I'm
sweetheart.
objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No,
the
it don't.
fact that I've already ruled on the admissibility is not something I'm going to revisit.
What I gotta say.
Hold on,
definitely
that door is, all right, it's, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
what I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions. So with that, I want to bring the jury back out. I will ask the state. I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what I'm
I'm not
doing.
interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it be
don't
proven
interrupt
on-
me right now. I'm trying to do something on my computer.
Would it be
and I need to
proven on the
focus.
record?
Say a word. Oh, and go ahead and put yourself on mute now.
It's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then. We can kind of tidy up the record and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right,
Jury already coming out.
I'll just stick
Okay, so go
All
ahead
right,
and sit it
for the
back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor. Should be proven at some point.
I don't know how to put this, but I'm kind of a big deal.
Remind me not to do that twice. Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
The state has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has
Admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
Most recent testimony, we, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had to scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
BS hearing?
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough.
John!
For the record. 13 and 14 were received as well. Do they have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right, thank you.
Here we
Right,
go.
then at this time, we are
We
going to
made
break
it.
for the lunch hour. I am going to
Wait, now she's going to call the lunch? Are you serious?
have everyone
Yep.
come back at 1:30. It's a little bit longer, at least.
You missed a
Oh my
horrible
God.
argument.
That's what I want to do
I
for the
came
lunch
back for
hour today. So
nothing?
all rise for the jury.
Let's slow clap them out, people. Let's slow clap them out.
Okay. Not the audio, just the video. Awesome. All right, then.
Thank you. Be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has
What you mean?
Verdict, idiot.
Request pertaining to what exactly?
I'll ask the question one more time. Do you have any requests to make at this time now that the
Motion
state
for a
has
directed
rested?
verdict.
I don't understand what you mean by that. That's why I'm trying to get
Yeah,
clarification.
because you're not a lawyer.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know
The world frightens and confuses me.
what would that be pertaining to.
I can't give you
don't
legal
know.
advice, sir. I'm
Giving you
just
the
asking the question to
option
make a
to
record.
make a motion
I'll ask
for a
you one more time. Do you have any
directed
requests to
verdict.
make now that the state is rested?
But you don't know what that is.
I don't understand.
All right, the other thing I want to do when the jury comes back out is, you will
Oh my
recall I
God.
read instruction 101 at the very end of the preliminary
Don't talk
jury
about the directed
instructions that just has to do with
verdict. We want them to
opening
waive that.
statements. I will read
Good.
that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence
just cut off
as it is introduced during the
most
trial.
of his avenues of
I must
appeal right
caution you,
there.
however, that the opening
Failing to make
statement
a
is not evidence.
move for
I'll read
directed
that.
verdict.
It's appropriate
They're all
given
gone now.
that Mr. Brooks
Congratulations.
deferred his opening statement
Which is
until the
beautiful.
start of his case.
That goes.
With that, we will
that-
take our lunch
all
break.
of
It's
your objections
12:09. If you could be back here at 1:25 and be ready to go
Basically
at
don't matter anymore.
1:30 with your opening
I
statement.
got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Yes.
At what point are we talking about? Do you want to use exhibits that have been received during your opening?
Your
Is that what
Honor,
you're
how do I
asking me?
practice
No,
law?
I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the
Yes.
state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Have
Are
you turned
they
them over yet?
documents from the discovery that you have?
They're documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give
for
me an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings, everything
Which
that I filed,
filing, sir?
every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So,
Offer your
are you
exhibits when you
talking
start.
about during your opening statement or during the course of the questioning of the witnesses
Just
that
you'll
you're
make the
calling?
ruling when
Your
he
Honor, with all
offers the
respect, I
information.
just clearly said
And be done.
filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what you're
filed.
referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that.
We know you don't
It would
understand.
only be relevant to obviously the matter. They would be relevant to anything
I
else.
can't answer that anymore. We're gonna take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
Oh, sweet Jesus. What?
Oh God, I need to go get lunch.
I'm trying
Otherwise,
to
I'm gonna lose my freaking mind.
All right. Thank you all for coming out. We're gonna close this down. I got to put one together here for what'd she say? 1:30.
She said, I think 125.
125. No, we're getting there. This trial's gonna end.
I forget what she said.
This trial's going to end because he supposedly has 13 witnesses, but I highly doubt he's got them. I doubt that he's coordinated with the state to get them for him, which was the procedure they had in place. So I think it's just going to crash and burn. But he will do an opening statement. We'll get that far.
Yeah, we'll see.
Then he'll decide whether or not he's going to testify on his own behalf. And then he can try to call witnesses, but I don't know how he's going to do that because he doesn't have any way of doing it.
Well, didn't he have the state serve the subpoenas for him?
He did. But he wasn't cooperating with him and telling him who he needed. The state made a record 54 times. If you don't tell us what witnesses you need, we don't know who to contact, and we can't do it for you.
I thought that was an ordering issue. But yeah, that's fair.
Well, I mean, I have no idea if he gets witnesses on the stand, he won't know what to do anyway. Which that'll be a train wreck. But I think he'll have a long, rambling opening statement, trip all over himself, and not be able to get anybody. Out of frustration, call himself so we can have another long, rambling narrative testimony thing, and then just get frustrated because he doesn't understand how to deal with witnesses and rest. That's my prediction.
Oh, you think he's ever going to rest? Do you think that other than forcing him, he'll actually rest?
He doesn't know enough to rest, but at some point the judge is going to say, you don't understand how to call witnesses. They're not here. It's because of your own fault. You're done testifying. So do you rest? And then he won't answer. And then the judge will say, okay, I'm going to take that as you resting because you're non-responsive. I think that's how this trial ends.
Fair enough. I think in my heart of hearts, I hope maybe he might learn something about what actually leading a witness is. But I don't actually think that's going to be likely.
But
anyway.
we are what is this, Thursday?
This is Thursday.
I don't even know where I am. Thursday. We have got Big Dummies opening statement set for about an hour and a half. I gotta put together the news stream, and I will see you all there. John, you coming back for it?
Yeah, I'll be back.
You can't miss this party?
I'm gonna run out and get some lunch because I was kind of hoping that
you don't want to be hangry for this man.
But all right, I'll be back.
You are the best. Thank you. I will see you all soon.
See you guys.